Hi, everyone. I think just for the sake of time, we'll kick things off. So firstly, thank you so much for taking out the time. I guess this is the perfect excuse that you can use now to everybody for why you missed gym. But as you may know, there's been some significant changes to the High Court rules, particularly with the introduction of Rule 67A, then the amendments to Rule 69 and Rules 70. Effectively, what we'll be doing during the session is going through those changes. We'll be leading off with what the position was prior to the amendments and what the position will be as from the 12th of April 2024. I'm Yusha Davidson, one of the directors of BriefCo. I'm joined with Jared Poole, who is the legal solutions manager at BriefCo as well. He has a significantly better voice than I do, so he will be leading the charge for this presentation, and then I'll be handling some of the questions along with Jared's assistant. So please, when it comes to time to ask Jared some questions, be as aggressive as possible, and for me, be as polite and kind as possible. I'll just share the screen and we'll kick things off.
Thank you, guys. So as Yusha said, my name is Jared Poole, and today we just wanted to take a moment up to be able to discuss some of the changes that's going to be effected in terms of the High Court rules. So currently, the situation that we deal with is that when you receive a cost order in your favor, what happens is that the formal taxation process is instituted, and that means that Uniform Court Rule 70 is applied. Now, under this court rule, the taxing master is allowed certain discretionary powers, and there are certain discretionary powers which have differed from division to division, meaning that there are certain practices that are currently ongoing in Pretoria and Johannesburg that don't happen in the Western Cape and vice versa. And what we wanted to do is first just go through what the current position is now, what those discretionary decisions look like at the moment, and then moving into where the actual rules are going to change with regards to the High Court litigation process in formal taxations. So we're going to kick it off first by looking at council's fees prior to 12 April 2024, which is essentially the current position that we have. And as per the current rules that we have, you'll see that your court order will look something along the lines of what you're seeing on your screen at the moment. Basically, the court will, the presiding officer will grant you your relief on a good day. You'll get all the relief that you requested in your notice of motion. And on one of the last prayers, you will essentially have a reference to your costs of suit. So your typical wording for a court order at the moment looks something along the lines of your judicial officer firstly identifying the scale that is going to allow to apply to your matter in terms of the recovery. And then also if there's going to be anything in addition to the scale that needs to be mentioned to allow for the taxing master to formally grant you recovery of any particular attendances or fees. In the current example here in front of you, you can see that the party and party scale has been applied, including the cost of two counsel for your recovery of your fees once you are in the formal taxation process. Now, what this means in terms of counsel's fees, and this is where we see some of the discretionary powers come into effect, is that there are certain rules that are currently in play. One of the rules is that when you have the cost of two counsel awarded, your cost of your second counsel is limited to 50% of the cost of your first counsel that's allowed in your matter. And in the Western Cape and Pretoria, we see a difference in what is allowed in terms of a senior counsel's rate and a junior counsel's rate as compared to Johannesburg. So just to go through some of these important inclusions, the discretionary powers in the Western Cape and Pretoria have resulted in the practice being implemented of a perusal rate of counsel for between 20 and 40 pages per hour and drafting at 4 pages per hour. Counsel is also allowed to settle any pages at a rate of 6 pages per hour, which is where any documents are drafted by your attorney that counsel then has to review in order to approve. Now, When it comes to the maximum hourly rate that's allowed for senior counsel in the Western Cape and Pretoria, we're looking at a maximum hourly rate allowable of about 4,000 Rand, and junior counsel, when acting alone, a maximum hourly rate of about 2,500 Rand. Now, this will all be very much dependent on the complexity of the matter and also of the experience of counsel. So the longer your counsel has been practicing, the more likely you are to get a higher rate allowable for the work that they are going to complete. In Johannesburg, as we can see here, the hourly rate for your senior counsel is a bit lower at 2,500, but your junior counsel's maximum hourly rate is at 2,600 Rand. So what this essentially means is that in the Western Cape, if you were to approach BriefCo and we were to represent you, we've got a very good track record of getting as good of an hourly rate as what we possibly can and as high of an hourly rate as what we can. And for senior counsel, if we were to get you 4,000 Rand an hour, that would mean that your senior counsel's rate would be allowed at 4,000 and your junior counsel's maximum hourly rate would automatically then be calculated at 2,000 Rand per hour. And this is then applied to any work where both senior and junior counsel are working on the same attendances. And when it comes to the perusal of documents in Johannesburg, we see the same formula applied in the Western Cape and Pretoria. However, when it comes to drafting, we see that senior counsel is allowed to settle and draft at 1,700 Rand per page, whereas junior counsel settles and drafts at 850 Rand per page. So there's a bit of a difference depending on which division you approach. And why this is so important is because of the rules that are going to be coming into effect that's essentially going to change this current sort of situation that we are facing now. When we look at the council's fees that are allowable in the SCA and the Concord, in the SCA and the Concord, the same rules apply, which is Rule 18, that then governs the formal taxation process for the Constitutional Court and the SCA. Now, under Rule 18 of the Supreme Court of Appeal rules, senior counsel, is allowed a maximum all-inclusive first day fee of 140,000 Rand. This is inclusive of all of his preparation and for any of the travel and accommodation and expenses that are incurred as part of that preparation. And the only way that this amount is increased is if your formal record exceeds 500 pages. In that instance, for every 100 pages that your record exceeds that 500-page mark, your counsel will be allowed an additional fee of 10,000 Rand per day as a maximum first day fee. What then happens is that for the subsistence of the matter, counsel will then be allowed a 2/3 rate for the additional days that he is in hearing. What then happens with junior counsel is that junior counsel is then allowed a maximum of 2/3 of the maximum allowed amount for senior counsel. So what happens is that this bracket operates as a maximum of what you actually incurred. So if your senior counsel charged you less than 140K, the maximum that you'd be able to recuperate would be that maximum which he actually charged you up to that amount. When it comes to the Constitutional Court, we see the perusal rates are similar in terms of the 20 to 40 pages per hour. We see the drafting rate also very similar at drafting at 4 pages per hour and settling at 6 pages per hour for counsel. But a difference we can see here is that in the practices of the Constitutional Court, your senior counsel is allowed a maximum hourly rate of 5,000 Rand. When your senior counsel and junior counsel are working on the same matter and you are allowed to recover cost of 2 counsel, you'll then notice that junior counsel is allowed a maximum hourly rate that's equivalent to 2/3 of whatever senior counsel charged. Now, these are, like we said, these rules are going to be changed soon with the amendments kicking in on 12 April 2024. And we're going to have a look at some of the amendments and how they really affect the way in which we would like for you to be able to prepare for your matters and to stand a better chance of recovering a higher amount of fees for your clients. So if we look at one of the significant changes that's first coming into play, when we're dealing with taxations currently, what happens is that the taxing master has a tendency to separate the work of an attorney versus the work of an advocate. And although the updates and amendments that are going to kick in are still going to recognize the work that's done by an attorney and an advocate, We also have the addition of Rule 69.8, which is going to recognize where an attorney acts as an advocate in matters. This implies that your attorney is now attending to all the work that would usually be completed by your counsel in a matter, which would include drafting any of the heads of argument, for instance, or attending any of the pre-trial hearings or the hearings itself. What we also have is that we are going to be doing away with the 50% cap on your second counsel's fees. And instead, what's going to happen is that now we are going to implement a scale application of how to actually work out how much counsel is going to be able to be awarded. Now, this brings in a lot of additional considerations for you when you are dealing with the matter, in that you want to approach the court and address the court on the issue of costs in the process of you actually conducting your matter. So no longer is it going to be where you're going to wait for the end of the matter, send the file off to the cost consultant and have them establish all the rules of engagement. Instead, now the onus is going to, in certain ways, shift on the litigants to address certain aspects of the litigation in order to justify a higher standard of recovery or a higher rate of recovery. What we are going to see is that with the implementation of these scales, there's going to be an increase in the amount of arguments that's going to be had during a trial, dealing specifically with the complexity of the matter, the value of the claim, and the importance of the relief to affect which scale your counsel's fees are going to be recoverable in. Where there's going to be a silence on which scale is going to be implemented, unfortunately, that's going to mean a limitation to scale A, and we'll have a look at some of the scales in a moment. The last amendment that's going to be kicking in is that which is relating to urgency. Now, we're already seeing this in certain practices where the taxing master wants to see the judicial officer make some kind of reference to urgent fees being allowed. And now it's not only going to be a discretionary play, but going to be one that's going to be included in the rules. So if we look firstly at Rule 69, and this is applicable to in party and party matters, like we said, the 50% cap on the additional counsel's fee is going to be removed, and we're going to see an implementation of the three scales. Scale A being 1,500 Rand or up to 1,500 Rand being allowed for your counsel, scale B 3,000 Rand, and scale C 4,500 Rand being the maximum allowable hourly rate for your counsel to recover fees on. And what is going to happen is that as you are going to justify the scale for your counsel to recover on, the judicial officer will then be able to, in their court orders, specify which scale both of your counsel is going to be allowed to recover their fees on. And also the discretionary power in terms of the taxing master is going to shift slightly, in that now the complexities are going to once again be argued before the taxing master to justify the maximum allowable amount in terms of that scale. So if we again look at the urgent matters, we now see an additional amendment coming in with Rule 70, in that now there is going to be a 15% surcharge added to all attorneys' fees as set out to the bill of costs in urgent matters. And what this means is that your bill of costs is going to go through the normal processes. Once the attorney's fees are calculated at the end of the taxation, a 15% fee is simply going to be added on in matters where there has been urgent relief, and that urgent relief has been recognized by the judicial officer. If we look at what we assume at BriefCo, the first example of what your orders are now going to look like, as I stated earlier, the first thing is that it's going to start right when you are drafting your notice of motion already and the relief that you are going to request. So in your notice of motion already, you are going to want to justify as high of a scale as possible for your client, and you're going to even want to address this in your arguments, in your supporting affidavits. We also suggest taking this into account when considering the amount of days you are going to need for argument, as depending on the opinions of both parties, the complexity of the matter might actually be a sticky point of argument when dealing with the justification of which scale to implement. Now, once again, we are going to just say that this is our suggestion of how we foresee court orders are going to be written up in future as from 12 April onwards, to make provision for some of the amendments that are coming into effect. So the first you can see over here is that Now, inclusive of mentioning the cost of 2 counsel, we also specify that first counsel's fees are going to be allowed as per scale C and second counsel's fees as per scale B, and including all costs relating to urgency. Now, what this will allow for is that once your tax consultant approaches the taxing master, they will then have the purview and the scope to be able to justify your senior counsel's fee up to the maximum of 4,500 of scale C and for the maximum allowed in scale B as well. You'd also then see, because of the mention of the urgency, that once the attorney's fees are calculated in these bills, that simple 15% surcharge will allow it to be added on the end of your matters. Now, if we deal with a matter in which there is only a attorney of record that is acting as if they are counsel, then what you will see is that although we're still on party and party scale, we'll see that there will be mention that the attorney that is appearing on record will be allowed to recover their rates as per scale B of the amended rules, including all costs relating to urgency where so relevant and applicable. The last example that we had, the first example that we had was actually the one that I wanted to refer back to in terms of seeing the difference of what the orders will look like. But as you can see, the cost orders and the relief that's requested in your cost orders now are going to be quite a bit more lengthy. And what this means is that the justification moving forward is going to then allow for your taxing consultants to then have better arguments when approaching the taxing master to justify that scale C or any urgency work that is going to be completed. And so that's essentially the purpose of this webinar, was to ensure that you are aware of these changes coming into effect so that you can incorporate this into any of the documents that you are currently drafting in any of your matters, and to be aware of this when arguing before your judicial officers in any of your matters as well. We'd just like to say thank you again for taking your time, and we're going to move over to the question and answer series now. And we look forward to accepting some of your questions.
So there's been some Q&As, it's just loading. Will the slides be made available to attendees? We'll be sending a recording of today's session to everybody, probably during the course of tomorrow. What I just wanted to add was that, as you all know, it's only coming into effect on the 12th of April 2024. There's going to be a lot of lessons by cost consultants and attorneys. We'll be sharing our lessons from absolutely every single division. The reality that we're faced with now is that Western Cape, Pretoria, Johannesburg, Bloemfontein, every single market operates completely differently when they apply the advocates' rules. And so what we're looking forward to seeing by these taxing masters to see that, are they going to adopt a strict hourly rate perspective to absolutely everything, or will Johannesburg adopt what they call the page formula for absolutely everything that they do? So as Jared mentioned, there was a page formula of a rate about 1,700 per page for drafting and settling for senior counsel, and 850 Rand for junior counsel. So how will those rules be affected by the introduction of these new scales? We'll all wait to see how that's going to play out. But effectively, I mean, as much as they call it the uniform rules of court, there's absolutely nothing uniform about it at all. So like I said, we will be keeping everybody updated with the latest developments in our section 67A, 69 and 70 will actually play out in practice come 12th April 2024. Additionally, just as a side note, your matters that have previously already been instituted, you don't have to panic and go back now and amend all your notices of motion or your summons and all the relief that's being sought. It's only for all of your matters that's being instituted or launched from 12 April 2024. And so what we're effectively going to be seeing is that taxation is going to be two separate systems that's running for all matters that were launched prior to 12 April 2024 and all matters that were launched as from 12 April 2024. So just know that when we do provide you with feedback, or when your cost consultant does provide you with feedback on the outcome of a taxation, just understand that there's really going to be two separate systems at play, and we foresee that the current system that's now in effect, that's coming into effect on 12 April, will allow for a greater recovery than what was previously allowed. The reason why I say that is simply simply because if you allow to recover both scale C for your first council and your second council, or even your third council for that matter, that makes a significant difference than immediately having your council's fees capped at 50%, your additional council's fees capped at 50%. But please hit us with some questions if you have any, and we'll be happy to address them. You know, I think in moments like this, we all learn from each other and what people are seeing in the different divisions. So it's good to have people from throughout South Africa also on this call. Please, you can either raise your hand and we can unmute you. Here we go. Oh no, that is me. Sorry. You can just raise your hand and then we can address the questions, or you can put it in the Q&A. Hi, what would the repercussions possibly be when order granted after 12 is not complied with the amended rules? Chamber booking. Okay, yeah. So if you don't comply with the new rules, effectively it's going to be on the lowest scale. So the same way where we read into any order, so let's just say costs are granted in favor of the applicant, we immediately read into that costs are granted on a party and party scale, inclusive only of one council. So the same rules are going to be applied then. It's going to effectively be costs on a party scale, inclusive of one council, but on the lowest scale. So that would be scale A. So your council would effectively then only be able to recover 1,500 Rand per hour. Let me, Jatheen.
Hi, Yusha. Thanks. So working through the rules, I get the sense that this has a negative effect on taking on matters on a cost recovery basis. Is that an accurate perception to have of these new rules, or is it really more of the same?
So maybe so Jatheen's coming from a perspective as an advocate who we work with in some of his matters for everybody else on the call. So really what we're finding is that to really cater for the maximum amount of recovery, it comes down to how council words their invoice. And what I mean by that is that on a party and party scale, an advocate is only allowed to recover, this is just an example, cost for a consultation where where not only the attorney is in the presence of the consultation, is in attendance at that consultation, but also the actual client. And so what we often find with council's invoices is that their invoice doesn't reflect the necessary wording to allow for the maximum recovery, both on a party scale and even in fact on attorney and client scale. So I think it comes more down to the way that advocates are preparing their actual invoices and then submitting it. And what you really want is for advocates to prepare their invoices in line with the actual rules, with a hindsight of this is how a taxing master is going to assess my invoice when it comes before them, so that it prevents any unnecessary items being taxed off. That is honestly the biggest problem that we're seeing in the legal cost consulting space at the moment when it comes to counsel. And I think the concern should more be along the lines of anybody that's charging over and above those scales, which is, I mean, there's a number of counsel out in the market that's over and above those scales. As long as you're fitting somewhere in between it, you're also remaining competitive at the same time. And as you know, there were guidelines that were regulating advocates and how much they could charge. The Competition Commission got involved and they said that was anti-competitive. I'm not sure why they've reintroduced the scale again in light of the fact that the Competition Commission has already made a decision prior to this about advocates' hourly rates and the fact that it was anti-competitive. But in any event, what you'll see now, you'll see more uniformity across the board of what councils charging, and industry rate being set. You're having your basic demand and supply being set right here by the Uniform Rules of Court. But I think to answer you very simply, I think that if you make sure that your invoices are prepared correctly, you shouldn't have to worry about whether or not you should take matters on contingency or not. Sorry. Okay, perfect. Going back to the Q&A. Will the judges also be made aware that they need to consider the specific cost relief in orders, as they will need to apply their minds to the scales, and they're not always familiar, may give rise to advocates requiring to argue taxation scales. So, as Jared mentioned, absolutely in all of your papers now, you're going to have to start making submissions on the scales that you want each of your advocates to be awarded on. And as part of making those submissions, Scale C will only be awarded in the event that the matter is considered complex, if they look at the value of the claim and the importance of the relief sought. So it's up to you to put those before the judicial officer for them to consider, and then they will be able to actually make a decision from the papers and on argument as to what to allow. Secondly, I think, we do a lot of training with the magistrates, the judges. We haven't provided as much training to the judges, but the taxing masters the taxing masters do in fact provide training to the judicial officers, the High Court judicial judges, as to what is allowed and what changes are coming up in the High Court rules. Are there any other questions? Look, I know a lot of people probably in the Gauteng market look at some of these rates and they're thinking 4,000 Rand for council, 3,800 for council. That is unfortunately how it currently stands. Previously we were, the reason why we brought up, the SCA and the Concord is because our team thinks that is likely going to be a change to the SCA rules and the Constitutional Court rules by virtue of the High Court rules being changed. You often find that when the High Court rules change, specifically relating to costs, it generally follows that the SCA and Concord follow soon. So I can only guess in the next couple of months we're going to see a change. From my previous question, will it be possible to then correct such an error by way of a chamber booking, or are there limitations? Clear, I think this is one of those issues where when you're seeking relief from the outset, this is effectively part of the relief now that you're seeking. To amend your relief post the hearing of the matter, you can't really do that. So it's only in certain instances, Jared.
That is what Leo. A lot of what we think is going to be the additional sort of requests that you're going to make for your relief will be able to be covered by the inclusion of further and alternate relief when you're including it in your notice of motion. So I know a lot of attorneys include that as a prerequisite in their notice of motion, even after all of the specific relief that they're granted or that they're asking for. And so what we are also thinking is going to happen is that the scope would be allowed because of the necessity of having to argue for your scales, that the scope would be allowed to argue your scales under that further and alternate relief to be argued before a judicial officer as well.
Are there any more questions? Okay, here we go. Q&A. Makes sense. Thank you. Okay, well, unless if there are no more questions coming through in the next minute or two, I think we can call this a day. And if there are any questions that do arise, please, you can just let us know. You can send us an email on info@briefco.co.za and we'll happily assist. Somebody asked, what are we doing about the backlog? So just to give you some updates on the dates in the major markets.
Before you should start, we're not in control of the backlog before you accept that that's our liability. We're not in control of that, but yeah.
So Western Cape, for Western Cape for unopposed matters, you're looking at December 2024. For opposed matters, you are looking at September 2024. I've specifically asked why the one is later than why unopposed is later than opposed. The clerk administering the dates also doesn't understand, but that's how it's currently sitting in Western Cape. In Johannesburg, you're looking at the backlog, you're looking at about a 3 months to 4 month waiting time period for your next taxation date, which isn't that bad. Or in Pretoria, you're looking at the next available date in October 2025. Now, that is a terrible backlog over there, and I think it comes down to the fact that Joburg has significantly more taxing masters employed than Pretoria. Pretoria, we're seeing about 4 or 5, whereas Johannesburg has 11. And that makes a massive difference. In Bloemfontein, East London, Port Elizabeth, you're looking at getting a date within 3 to 5 weeks, which is significantly quicker than every other market. So these are party and party costs and not attorney-owned client, which we can continue bill our clients. So going back to this concept, so there's two scales of costs when you're looking at recovering costs against a losing party in a litigation matter. That's your party and party costs and your attorney and client costs. I like to think of it almost as a tennis ball, that party and party costs is, and attorney and client costs is a soccer ball. It's really just in a party cost, you're only allowed to recover those costs that's reasonable and necessary, and in terms of the tariff. On an attorney and client scale, again, you have to apply by the tariffs that's applicable, but you can include more attendances than what you could have included as per the party and party scale. The reason being is that an attorney and client scale order is a punitive cost order. It's really there to ensure that the other side the reason why it's called the punitive cost order is punished for the conduct in the matter. Now, an attorney and own client bill of costs, that does not apply when seeking to recover costs against a losing party in a matter. An attorney and client scale is only applicable when you're seeking to recover costs against your own client in terms of an engagement letter which you have signed. And now on that point, we have seen numerous times where we've tried to have attorney and own client bills taxed. So that's where you're suing your own client to recover costs against them. The taxing masters are becoming less sort of keen to tax these bills of costs. The reason being, since the inception of the Fee Dispute Resolution Committee, they've been more susceptible to referring it to the Fee Dispute Resolution Committee, which was formed under the auspices of the Legal Practice Act. And through that committee, which is generally comprised of 2 attorneys and an advocate, they will determine the reasonableness of the fees charged by you and even your counsel, and they'll make a ruling as to what your client should be liable for. The only problem with this Fee Dispute Resolution Committee is that any ruling made by them is not binding at all, meaning you cannot take that ruling and use it as a liquid document and obtain a warrant or it. Effectively, what you'll have to do is you'll have to take that ruling from the Fee Dispute Resolution Committee, go back to the taxing master, have the taxing master make their ruling based on the LPC's ruling, and only then will you have a liquid document that's capable of execution. So the real question is, why did we go all the way through to the Fee Dispute Resolution Committee? I think that truly it's just a new committee that's formed and everybody's still trying to find their way around it. The major other issue is the backlog that's sitting at the Fee Dispute Committee. You're looking at waiting about 6 months to have a matter decided, and then obviously you have to go back to the taxing masters to have a ruling. So all in all, you're looking at about 1.5 years to 2 years just to get that fees back from your client. So it is really a frightening process at the moment, but we are in discussions with the LPC as BriefCo, and also Jared, who sits on the Cape Town Attorneys Association, to ensure that we can sort of introduce some additional mechanisms to make this process more seamless.
And just on that point as well, a lot of the concern is coming in now with the recovery of your fees being as a percentage of what your client was charged. And so with these changes, the intention is to try and get that percentage a bit higher. Whether that practically happens or not is what we're going to see once these rules all roll out. So that's why we're also watching it very closely. As you know, we keep a lot of data on all the hearings that we attend across the country. And so what we were actually going to measure is whether or not these changes actually result in a higher rate of recovery or percentage recovery for your clients' legal fees, or whether it needs to be something that is going to be discussed at length again with an alternate way of trying to approach that little issue of the recovery rate of fees at the moment.
Are there any other questions? Perfect, Justine, just giving a thumbs up. Okay, perfect. So unless there are any more questions, or you can raise your hand if you don't want to type, we will give it about 30 seconds more just in case, and then we will close things off. And ideally, everybody can make it to the gym before 6 o'clock. Okay, perfect. Thank you so much, everybody. It's been absolutely fantastic. We always prefer doing things in person, just to see some shock and horror at some of these rates that are allowed for attorneys and counsel. But thank you for all attending today's session. As I mentioned, this recording will be made available, and please feel free to distribute it amongst your firm. And we are happy to take questions tomorrow, for the rest of the week, and in time in memoriam. We will always be there to address any questions on the law of costs. So thank you again from the BriefCo team, and we look forward to hopefully hosting a couple of more webinars with some more changes that are in the pipeline. Thank you so much, everybody.